There's so much going on in the court system right now, there's absolutely no way to keep track of all of it. I'm Brian, and this is the morning report for July 30th, 2025. Let's talk about what's happened in these federal court cases in the last 24 hours. I'm going to start with a couple of administrative filings. They're not super exciting, but they do tell us a couple of very important things. The judge in Newsom v. Trump has issued an order for pretrial preparation for a civil bench trial and set a 3-day trial for August the 8th. Now, this whole time I've been telling you, every time you hear on the news that the court did this or did that, they probably haven't done anything because we haven't had time to get through all of the pretrial stuff and all the discovery stuff and actually get to the trial phases, so nothing's really happened yet. Well, this means that we are finally reaching the point where some stuff is starting to happen. The second case, American Public Health Association versus NIH, just issued kind of some clerk's notes, but they also said that the judge is setting discovery dates. He's setting a deadline for trial of September 15th. So we are moving into those phases where we're going to start seeing trials and we're going to start seeing actual verdicts and actual orders that stick. So be prepared for that and for me to stop treating the media quite so sarcastically. Next, in Colorado v. Department of Health and Human Services, we have a judgment of voluntary dismissal following a consent motion to dismiss. So this is an appeal. It was an appeal to the First Circuit of a withdrawal of funding case. It was brought by a bunch of states against the Trump administration. The plaintiffs allege that defendants arbitrarily terminated $11 billion of public health funding in violation of the APA, the Administrative Procedures Act. I'm not entirely clear why this was voluntarily dismissed, but this was a consent motion, so both sides agreed to it. It's possible that either an agreement was reached of some sort, or there's another case somewhere that's kind of the issues have merged, and so they don't want to redouble efforts. Not really sure, but this has been voluntarily dismissed, at least in the Court of Appeals. In Doe v. Noem, the case I talked about yesterday, we have another attorney withdrawal. This is another DOJ attorney that's left the DOJ. This guy had been there for just shy of 10 years. So this is not great news. This keeps happening, and these are long-term people who've been at the DOJ for a long time. So not super common, and it's becoming more and more common. Okay, City and County of San Francisco v. Donald Trump. This is an Immigration Enforcement and Sanctuary Cities case. And the plaintiffs have filed a motion for a second preliminary injunction. So these are additional plaintiffs. These are cities and counties in California that have been affected by the Trump administration policies, and they are asking for a second injunction to protect them as well. There was already an injunction for the first set of plaintiffs. This is a second set of plaintiffs, and they want an injunction too. They say that they have decided, as is within their right under the 10th Amendment, to restrict the use of their own local resources to enforce federal law and federal policy, and that they are being punished for exercising those rights by withholding funding and other intimidation techniques. So, for example, they say that the Department of Treasury Secretary Sean Duffy announced that the agency would only fund recipients that cooperate in the enforcement of federal immigration law. HUD has also added immigration-related conditions to its grant programs, including continuum of care and community development block grant programs, which community development block grants are kind of a favorite of mine, but that's a side note. These are non-competitive grants that support services to address homelessness and boost economic development. So the plaintiffs have asked the court to grant a second injunction to end what they call coercive threats and end federal funding that they say are hanging over their heads. Now, it also looks like the government has already filed a response to this. They filed it about 2 hours later. So my guess is that it looks quite a bit like their response to the first motion for injunction, because it's probably the same stuff. So probably why they were able to get it out so fast. Okay, final case. Catholic Bishops v. Department of State. This was related to the refugee resettlement program. The United States Conference of Catholic Bishops had a program. They participated in the government's resettlement program, but that partnership came to an end after the South Africans were brought to the United States, and the Conference of Bishops was essentially asked to pay for their living expenses and resettle them. But they have filed a consent motion, which means both sides have agreed to a stay, which puts the whole thing on pause because the bishops and the government have agreed to work out a structured wind down of this agreement, of this program. And they say a stay would, quote, result in resource savings for both of the parties and the court without any risk of harm. So this motion, being a consent motion, it was pretty easy to make a decision on. So it was granted yesterday. And so this case is now at least stayed for the moment to see if they can reach an agreement. Okay, that is sort of a quick run through of what happened yesterday. Please follow me for more information about the law and government, and I'm going to start trying to do these a little bit more regularly. Let me know if you're interested in hearing this, and if you are, please watch these, comment, like, get them out there so people will see them. If people watch them, I'll keep making them. All right, thanks everybody. Have a great day.